Imagine a child suing their parents for the crime of bringing them into existence without consent. It sounds like a plot from a dystopian novel, but in 1990, a man named Adam legally sought $700,000 from his parents for precisely this reason. His argument wasn't about neglect or abuse. It was a profound philosophical and legal challenge to the very act of procreation. He claimed that because he couldn't have consented to be born, his parents were liable for the suffering and disadvantages he experienced in life. This wasn't a case of a minor seeking emancipation. Adam was an adult, legally capable of making his own decisions, and he believed his existence itself was a wrongful act committed by his parents. The court had to grapple with an unprecedented question. Can you incur damages simply by being alive? And if so, who is liable for that existence? Adam's lawsuit was framed as a wrongful life claim, a highly controversial and rarely successful type of litigation in U.S. courts. Unlike wrongful birth claims, where parents sue a doctor for failing to prevent the birth of a child with a severe disability, wrongful life claims are brought by the child themselves. Adam argued that he would have preferred not to have been born at all, rather than live with the perceived disadvantages of his life. He wasn't alleging medical malpractice, but rather a fundamental violation of his autonomy by being brought into the world. He sought $700,000 in damages, which he detailed as compensation for a lifetime of perceived suffering, lack of opportunities, and the general burden of existence. The legal system, built on principles of foreseeable harm and measurable damages, was completely unprepared for such a novel and existential claim. How do you put a dollar amount on not being born? This was the central, almost impossible challenge for Adam's legal team. They tried to quantify his suffering by detailing his life circumstances, but the court immediately faced a logical dilemma. To award damages for not being born, it would have to compare his current existence with the state of non-existence. This comparison is inherently impossible from a legal standpoint, as non-existence has no legal standing or measurable attributes. If Adam hadn't been born, he wouldn't exist to claim damages. This paradox is why wrongful life claims are so problematic in American jurisprudence. If the court were to side with Adam, it would open the floodgates for countless similar claims, fundamentally altering the legal landscape of parenthood. The court had to weigh the deep philosophical implications against established legal principles. Adam's parents, understandably shocked and deeply hurt, defended themselves against this extraordinary claim. Their defense wasn't complex. They simply exercised their fundamental right to procreate and raise a family. They argued that they had acted in good faith, raising Adam to the best of their abilities, and that their actions were never intended to cause harm. Furthermore, they pointed out the logical absurdity of the claim. How could they obtain consent from someone who didn't yet exist? They also highlighted the potential chilling effect such a ruling would have on families across the nation, making every act of childbirth a potential legal liability. Their lawyers emphasized that while Adam might be unhappy with his life, that unhappiness could not be legally attributed to the act of his birth itself. The court listened intently, understanding the gravity of the decision. The court's answer to Adam's astonishing lawsuit was clear and unequivocal. His claim for $700,000 was rejected. The fundamental legal principle behind this decision is that U.S. law does not recognize a cause of action for wrongful life. This means that a person cannot sue for the damages of being born. The primary reason is the impossibility of comparing existence with non-existence. To award damages, the court would have to determine that non-existence is a preferable state to existence, which is a moral and philosophical judgment beyond the scope of legal adjudication. Furthermore, the court recognized the immense societal implications. If such claims were allowed, it would impose an unbearable legal burden on parents and could even be interpreted as devaluing human life. This decision solidified a long-standing legal stance in the U.S., but left many wondering about the deeper ethical questions. A common myth stemming from cases like Adam's is that parents can theoretically be sued for anything a child dislikes about their upbringing, even for being born. This is false. While there are specific circumstances where children can sue parents for severe neglect, abuse, or financial mismanagement, especially if the child is a minor and a guardian ad litem is appointed, the act of being born itself is not a legally recognized harm. The U.S. legal system prioritizes the right to procreate and the sanctity of life. Cases like Adam's, seeking damages for the fact of existence, are consistently dismissed. This isn't to say legal battles between family members don't happen. They do, frequently involving inheritance, property disputes, or child custody. But the idea of suing for your very existence? That remains firmly in the realm of legal impossibility, a boundary the courts are unwilling to cross. This distinction is crucial for understanding the limits of legal action. It's vital to distinguish Adam's wrongful life claim from wrongful birth lawsuits, which are recognized in many U.S. states, though they remain controversial. In a wrongful birth claim, parents sue a healthcare provider, usually a doctor, for negligence that prevented them from making an informed decision about terminating a pregnancy. For example, if a doctor fails to diagnose a severe fetal abnormality and the parents state they would have chosen abortion had they known, they might sue for the extraordinary medical expenses and emotional distress of raising a child with that condition. The key difference is the defendant, doctor, not parent, and the nature of the claim, negligence, not the act of birth itself. The damages sought are for financial burdens and emotional suffering due to medical error, not for the child's existence. This distinction highlights the court's careful line drawing in these sensitive cases. Had Adam's lawsuit succeeded, the societal implications would have been catastrophic. Imagine a world where every new parent faces potential litigation from their future child, demanding compensation for being brought into the world. It would fundamentally alter the concept of family, parental responsibility, and even human procreation. The fear of being sued for merely existing could deter people from having children or lead to an unimaginable burden of liability insurance for prospective parents. The court's decision, therefore, wasn't just about Adam. It was about protecting a core societal institution, the family, from an unprecedented legal assault. It affirmed that while individuals have rights, these rights don't extend to holding others accountable for the fundamental act of bringing them into being. This protective stance prevents legal chaos and upholds a basic human liberty. The precedent set by cases like Adam's ensures that wrongful life claims have virtually no chance of success in U.S. courts today. While legal landscapes can evolve, the core philosophical and logical hurdles remain insurmountable. Any future attempt to sue parents for being born would face immediate dismissal based on established legal principles. However, this doesn't mean the underlying ethical questions disappear. As technology advances, particularly in reproductive science, new ethical dilemmas will arise. For instance, questions around genetic screening, designer babies, or even artificial wombs might prompt new forms of legal challenges regarding a child's right to a certain kind of existence. But suing for the fundamental act of being born? That door appears to be permanently closed in American jurisprudence. This provides clarity for parents, but the legal field is always evolving in other areas. Here's what happens if someone attempts a wrongful life claim today. They face significant legal fees, likely in the tens of thousands of dollars, for a case that is almost guaranteed to be dismissed at an early stage. For example, if Adam had pursued his case in a major city like New York or Los Angeles today, retaining an attorney for the initial filings, research, and motion to dismiss would easily cost upwards of $20,000 to $50,000, even before discovery. The court would likely grant a motion to dismiss, citing a lack of a recognized cause of action, meaning the plaintiff would spend a substantial sum for no legal recourse. This financial burden is a powerful deterrent, highlighting that while anyone can file a lawsuit, not all lawsuits have legal merit. It's a costly mistake to pursue claims that fly in the face of established legal precedent. The core legal lesson from Adam's case is that the U.S. legal system, while striving to protect individual rights, draws a firm line when it comes to the act of procreation. You cannot sue your parents for the mere fact of your existence. While individuals certainly have the right to seek redress for genuine harm, that harm must be legally recognizable and quantifiable within the framework of existing law. The decision underscores the judiciary's role in balancing individual grievances with societal norms and preventing legal chaos. It also subtly reinforces the idea that life, in itself, is not a legal injury. It's a complex intersection of philosophy, ethics, and law, ultimately affirming the fundamental right of individuals to choose to have children without the specter of future litigation based solely on the act of birth. This case provides a strong precedent for parental peace of mind. While Adam's specific legal claim failed, his case sparked important conversations about autonomy, parental responsibility, and the nature of consent. It forced legal scholars and ethicists to re-examine the boundaries of individual rights and where those rights intersect with the fundamental biological processes of life. Although the court ultimately dismissed his claim, the philosophical questions he raised continue to resonate. Can a child truly consent to their own existence? Is there an unspoken contract between parent and child? These are questions that the law cannot fully answer, but cases like Adam's bring them to the forefront. The legal system provides a framework for resolving disputes, but some questions stretch beyond its capacity, delving into the very fabric of human experience. It makes you consider the profound implications of our own existence and the choices made for us. Adam's audacious lawsuit for $700,000 against his parents for being born ultimately failed, demonstrating that U.S. courts do not recognize wrongful life claims. The legal system simply cannot compare existence to non-existence or assign monetary damages for being alive. If you're interested in other extreme legal challenges to family structures, you might be wondering about the legal ins and outs of adult children suing parents for emotional distress from their upbringing. We cover that in our video titled, "Can You Sue Your Parents for a Bad Childhood?" Go watch that one next to understand the very different legal hurdles involved. And if you found this story thought-provoking, please consider subscribing for more true U.S. legal cases and courtroom dramas.